Welcome to our distinguished speaker, Tan Sri Abdul Ghani Patel. Contrary to what has been reported by the government for the past few months, I mean, he looks very healthy as far as I'm concerned. Well, thank you to Mr. Stephen Chiru, President of the Malaysian Bar, for his incisive opening speech. What he has mentioned, he has raised vital and crucial issues which we should be considering with great thought. Now, the reason why this issue about SOSMA came about and become the hot topic of the day is none other because of the recent arrest of Matthias Chang as well as Dato Khairuddin. Before the arrest of Matthias Chang and Dato Khairuddin, there have been numerous arrests. Stephen Chiru had mentioned the number of people who have been arrested under SOSMA, but of course the public wasn't very aware of the implication of SOSMA, because mainly SOSMA had been used against individuals who are suspects, individuals who are believed to be involved in terrorist activities. But when it comes to Dato Sri Khairuddin and Matthias Chang, nobody considers them as terrorists. Well, the appearance, obviously, they do not resemble any non-terrorists, and the issues that they talk about or the issues that they're advancing got nothing to do with the national security or threat to public order, and that's why the public are a bit concerned about the usage of SOSMA. Now, in order to understand SOSMA, I mean, it is important for us to go back to the Federal Constitution, and then from there on, we will see how SOSMA derives its exceptional powers, whereby it can suspend and undermine certain fundamental liberties which had been enshrined in our Federal Constitution. Now, before we proceed any further, let us remind ourselves that the law is nothing more than a tool. In the words of Professor Alan Dershowitz from Harvard University, in his book Letters to a Young Lawyer, this is a very poignant excerpt which I find it very, very interesting, and I think it's something which we should be able to consider. Don't love the law. It will inevitably disappoint you. Understand the law is a tool, a mechanism, a construct. It is a false idol, like so many others in life. Don't respect the law unless it merits your respect. The law in Nazi Germany or in apartheid South Africa or in the Jim Crow South did not deserve respect. The Supreme Court's decision in Bush against Gore should be followed. That's what it means to live under the rule of law. But it should not be respected any more than the rope cheaters who wrote it should be respected. The law today sometimes deserves respect, other times it deserves condemnation. It must always be obeyed, but it need not be admired. Honesty is more important than respect. And if you don't love the law, what should you love aside from your loved ones? Love liberty, love justice, love the good that law can produce. So with these remarks, I will now proceed to discuss about SOSMA. Under SOSMA, you can see there are various parts to it. The important parts will be part 2, which deals with special powers for security offences. And this particular part deals with the arrest as well as telecommunication interception, whereby it confers powers to the authorities to intercept our communication. So the fact that we live in a modern society with advanced technology, we have smartphones, that doesn't make us freer. On the contrary, it makes us prisoners, because our communication, our daily activities can easily be monitored by the authorities. And as what had been mentioned by Mr. Stephen Chiru, that without judicial oversight, that particular provision can easily be abused. Then you have part 3 of SOSMA, and this is where it allows the authorities to use the electronic monitoring device in order to monitor the movement of individuals or suspects who are being investigated under SOSMA. And then Part 4 deals with sensitive information. This is more relevant when it comes to the trial of individuals who are being charged for security offences, especially in a situation where certain sensitive or confidential information is required to be adduced or tendered in court, and that particular part deals with that particular issue. And then you have Part 5, which deals with the provisions pertaining to the trial of security offences. And Part 6 is where, I have serious concern, because this is a situation where witnesses are allowed to give evidence without his identity being made known, not only to the accused, but also to the defense counsel who's representing the accused. And then you have Part 7. This is the part where it allows certain special provisions relating to evidence, evidentiary aspect in a trial, whereby that particular part allows the prosecution to override the Evidence Act 1950. So there are certain exceptions which allows the prosecution to utilize those provisions in SOSMA in order to establish or to prove a case against a suspect. SOSMA, as what has been mentioned earlier, was introduced as a result of the abolishment of the Internal Security Act. Both acts, both legislations, were passed pursuant to Article 149 of the Federal Constitution. Despite the fact that both were legislated pursuant to Article 149 of the Federal Constitution, there are differences and there are some similarities. The main thing that we have to appreciate and understand is that the Internal Security Act as well as SOSMA both were introduced with the main objective in order to combat threats or subversive action against the Federation. That is the main aim and objective of SOSMA as well as the Internal Security Act. Under ISA, as all of us are aware, is that it allows the executive to detain individuals without trial. And such detention can go up indefinitely. Whereas under SOSMA, with the exception of the 28 days plus the 24 hours, there is no indefinite detention under SOSMA. But if you read the medias, you have individuals, you have politicians, you have public figures saying that person has been detained under SOSMA, there's a preventive detention. That is not entirely correct. The provisions under SOSMA, which allows for detention up to 28 days, is merely a provision to facilitate investigation. But whether or not that duration is reasonable or not, that's a different issue altogether. But the objective of having that provision is merely to facilitate investigation into security offences. Now, under the Federal Constitution, so Article 5 clearly says that a person can only be detained up to 24 hours in order to facilitate an investigation. If a person has to be detained beyond 24 hours, you have to obtain a court order, a remand order from a magistrate. That is what is stated in the Federal Constitution. However, SOSMA seems to be an exception to that particular provision. And the reason being is because SOSMA is a legislation that was passed under Article 149. We'll come to that point in greater detail later. And then SOSMA doesn't have an ouster clause, whereas ISA you have an ouster clause whereby you can't even challenge the executive order of detention. In a nutshell, SOSMA is a CPC, Criminal Procedure Code, plus Evidence Act for security offences. SOSMA deals with merely post-charge, but ISA ensures that there is no need to be charged. So there's a difference there. So ISA, you don't have to charge, even though it creates, even though the abolished ISA has offences, but you rarely see people being charged under the then ISA. Now, these are the three main problems that I see when it comes to SOSMA. First and foremost, SOSMA seems to exceed the parameters allowed by Article 149 of the Federal Constitution. Secondly, it seems to be disproportionate to the aim of the legislation. And thirdly, no rational nexus between certain provisions of SOSMA and the object of the law. Now, these three main issues are issues which my legal team and myself had discovered in the course of representing two individuals who have been charged for a particular security offence. And of course, SOSMA seems to be the procedural law that is being applied. And these are the issues that were raised in the course of the trial. Okay, now let's understand Article 149. Then we can understand why is it under SOSMA certain individuals can be detained up to 28 days. There seems to be certain infringement on the fundamental liberties. I hope it's not too small. Anyway, for the benefit of those who do not have it or those who have bad eyesight, I'll read it out. Now, Article 149, Clause 1 reads, if an Act of Parliament recites that action has been taken or threatened by any substantial body of persons, whether inside or outside the Federation. So, we're dealing with a situation if there is an action that's been taken by a group of individuals, whether from the Federation or outside the Federation, and the objective is to cause or to cause a substantial number of citizens to fear organized violence against persons or property, or to excite disaffection against the Yang di-Pertuan Agong or any government in the Federation, or to promote feelings of ill will and hostility between different races and other classes of the population likely to cause violence, or to procure the alteration otherwise than by lawful means of anything by law established, or which is prejudicial to the maintenance or the functioning of any supply or services to the public or any class of the public in the Federation or any part thereof, or which is prejudicial to public order in or the security of the Federation or any part thereof. This is the important part. Any provision of that law designed to stop or prevent that action is valid, notwithstanding that it is inconsistent with any of the provisions of Article 5, 9, 10, or 13, or would, apart from this article, be outside the legislative power of Parliament, and Article 79 shall not apply to a bill or such an act or any amendment to such a bill. So what it means is that if you have a piece of legislation that recites this particular scenario in the preamble, then it allows the suspension of certain fundamental rights. So that's why Article 5 can be suspended if a law is legislated pursuant to Article 149. Article 10, freedom of speech, freedom of assembly, can be suspended if there is a particular law which was passed pursuant to Article 149 of the Federal Constitution. So what is important is for us to look at the preamble of a particular legislation and see whether or not Article 149 was invoked, or whether that piece of legislation was legislated within the ambit or purview of Article 149. Now, if it doesn't come within Article 149, then obviously you cannot suspend certain fundamental rights under Article 5, under Article 10. Okay? Now, this is what Article 149 of the Federal Constitution says. But let's look at the preamble of SOSMA. The preamble of SOSMA reads, whereas an action has been taken and further action threatened by a substantial body of persons both inside and outside of Malaysia. And then you can see there are 4 scenarios being cited. The first one, to cause a substantial number of citizens to fear organized violence against persons or property, which is essentially Article 149, Clause 1, Subclause A. And then 2, to excite disaffection against the Yang di-Pertuan Agong, which essentially is Article 149, Clause 1, Subclause B. And then, which is prejudicial to public order in or the security of the Federation or any part thereof. That is essentially Article 149, Clause 1, Clause F, yes, that's correct. And then 4, to procure the alteration otherwise than by lawful means of anything by law established. So that is essentially Article 149, Clause 1, Clause D. So you can see that there are 2 scenarios which have been omitted from the preamble of SOSMA, i.e., Subclause C and Subclause E. Now, subclause, let's go back a bit. Subclause C deals with to promote feelings of ill will and hostility between different races and other classes of the population likely to cause violence. And Clause E, which is prejudicial to the maintenance or the functioning of any supply or service to the public or any class of the public in the Federation or any part thereof. Now, Subclause E may be interesting if you want to discuss the case of Dato Khairuddin and Matthias Chang. Okay, just bear this in mind, and you can see whether or not SOSMA was intended to cover or to deal with this, the factual matters involving Dato Khairuddin and Matthias Chang. So a quick comparison between Article 149 and SOSMA. You can see that SOSMA only cited clauses A, B, F, and D of Article 149 in its preamble, and SOSMA does not cover situations as set out under Article 149, should be Clause 1, C, and E. Now, there are 2 other legislations which deal with terrorism. Mr. Sivantiru mentioned the Prevention of Terrorism Act 2015. Now, if we were to look at the preamble of the Prevention of Terrorism Act 2015, of course, Article 149 was cited as well, was mentioned. So it is a legislation made pursuant to Article 149. I'm sorry, it's not in the slide of the handout. But as far as the preamble, it is very short and brief. It reads, whereas an action has been taken and further action is threatened by a substantial body of persons both inside and outside Malaysia, which is prejudicial to the security of Malaysia or any part of Malaysia. So the Prevention of Terrorism Act 2015 only refers to one particular scenario under Article 149, Clause 1, which is Clause F. So it doesn't mention, it doesn't cite about the other factual scenario as set out under Article 149, Clause 1. So you can see that Prevention of Terrorism Act 2015 is very specific. It's only intended to that particular factual scenario. Now, apart from the Prevention of Terrorism Act 2015, there is another piece of legislation, Special Measures Against Terrorism in Foreign Countries Act 2015. Now, this is also another piece of legislation which was introduced in order to counter or to deal with threats of terrorism. However, because the objective of the Act is to deal with terrorism in foreign countries, and that's why in the preamble of that particular Act, you will not find Article 149 being cited in the preamble. Because Article 149 is specific, is only to deal with threats to the Federation, regardless whether or not the threat is within or from outside the Federation. So we have to understand this basic structure first in order to understand SOSMA in greater detail. So the main thing that we have to appreciate and understand is Article 149 of the Federal Constitution. Whether we like it or not, it is in our Federal Constitution. It is there. And that's why we had the ISA the last time. and now we have SOSMA. But whether or not these legislations are being used in order to achieve the aim that it was supposed to be, that is a different issue. That is something which we can always discuss. So if to look at the preambles of SOSMA, Prevention of Terrorism Act, the Special Measures Against Terrorism in Foreign Countries, you can see that the preambles are different. This preamble, though it is not the main part of the Act, but it is important in the context of this legislation because these are the enabling provision or enabling words which allow the Act to suspend some of your fundamental liberties. So we cannot treat the preamble lightly. So in order to interpret the scope and the ambit of a particular legislation, especially those which were legislated pursuant to 149, then you have to ensure that the application of the law, the interpretation of the law must be within the boundaries, the parameters of Article 149, or at least what had been cited as the preamble. You cannot exceed it. So how SOSMA exceeds Article 149? If we were to look at Section 2, Section 2 of SOSMA clearly says that the Act shall apply to security offences. The word shall there commonly denotes that it is mandatory. That means there is no discretion conferred to the court. So Section 2 of SOSMA stated all security offences shall be tried using SOSMA, because SOSMA shall apply to all security offences. So this begs the next question. What amounts to security offences? And you have Section 3 of SOSMA, which states that security offences means offences specified in the first schedule of SOSMA. And what are the offences that have been set out in the first schedule? Essentially, they are offences under Chapter 6 and 6A of the Penal Code. Now, Chapter 6A of the Penal Code deals with security offences. It's very wide. There are numerous sections under Chapter 6A, and Chapter 6 of the Penal Code deals with offences against the state. Now, the problem, if you were to look at the offences seems to be a bit wide in its application, because certain offences under Chapter 6 and Chapter 6A of the Penal Code appears to fall outside the scope of the preamble of Article 149 as well as SOSMA. For example, the definition of terrorist act under Section 130B, sub 2, and if you read that particular section together with 130B, sub 5, covers a situation dealing with any person or property situated outside Malaysia. And then it also deals with public of a country or territory other than Malaysia. So you can see that while you had the substantive legislation, the Penal Code, Chapter 6 and 6A, has wide array of offences, and some of them seems to deal with situation where the terrorist threat seems to extend beyond the boundaries of the Federation. So this begs the question, does it fall outside the scope of the preamble? Does it fall outside the scope of Article 149? If you remember what I mentioned earlier just now, Article 149 only deals with threats to the Federation. It doesn't deal with threat to the America, United Kingdom, Australia, no. I'm not saying that you cannot have laws to deal with those kind of situations, you can. But if you want to use Article 149, and if you want to suspend certain fundamental rights, then you have to make sure that the substantive offences are only limited to situations where the threats are targeted to the Federation. So for example, if we say that so and so has been charged because he is trying to start an act of terror or initiate or spread an act of terror to country A, which is outside the Federation, does it come within Article 149? No, it doesn't. Does it come within the preamble of the SOSMA? No, it doesn't. So these are the things that we have to look into. There appears to be a legal anomaly when it comes to the application of SOSMA and when you try to try the substantive offences under the Penal Code. Okay, another thing that we have to bear in mind is that Article 4, Clause 1 says that any law passed after Merdeka Day which is inconsistent with this Constitution shall, to the extent of the inconsistency, be void. So if there is any law which has been passed after Merdeka Day and the law or the provisions of that particular law are inconsistent with provisions of the Constitution, it shall be void. So if there's any law which infringes Article 5, it definitely be void. The only saving provision is that if it comes within Article 149. So Article 149 allows the law to be valid notwithstanding it is inconsistent with Article 5, 9, 10 or 13, provided that it is within the permissible limited parameters as set out in Article 149. So if SOSMA exceeds the parameters of Article 149 and is consistent with Article 5, 9, 10 or 13, then obviously SOSMA is void. Another aspect, another complaint that I have with regard to SOSMA is that there is no rational nexus between the provisions of SOSMA and the aim of SOSMA. As you can see from the preamble, is that, and whereas Parliament considers it necessary to stop such action. Now, the meaning of stop is very clear. You want to arrest the situation, you want to put it to an end, you want to cease that particular problem. So action or threat would have stopped when arrest has been affected or when the accused has been charged. So the moment you're able to arrest a particular person, the moment you've been able to charge a particular person, that issue or the problem they're trying to tackle had been dealt with. So if you want to have a special legislation under Article 149 in order to deal with terrorism, you can have those provisions. But the moment you are able to arrest the person and produce the person in the court of law, then there should not be any special provision that infringe on the rights of the accused person. So if you look at how SOSMA had been set out, as I've mentioned earlier on, you have provisions dealing with arrest, interception of communication for purpose of investigation, and then you have parts which deal with trials, evidence. Now the parts which deal with trial, evidence, to me should not be there in the first place because you have wide-ranging powers under the earlier parts in order to arrest, to investigate, and to deal with the situation. Once you are able to arrest the suspect, you bring the suspect before the court of law and let the normal due process, let the person be tried subject to the Normal Evidence Act as well as the Criminal Procedure Code. Now, Article 149 only allows SOSMA to be inconsistent with Article 5, 9, 10, and 13. But Article 8, the provision which deals with equality, is exempted. Now, Article 8, Clause 1 states that all persons are equal before the law and entitled to the equal protection of the law. In the case of the federal court case of Lee Kuan Yew against PP, the effect of Article 8, Clause 1 is to ensure that legislative, administrative, and judicial action is objectively fair. And in the case of Azmi Sharom, the recent decision of the federal court says that under Article 8, Clause 1, laws must be proportionate to be consistent with the federal constitution. So you have to have provisions which are proportionate to the objective of the act. If it's disproportionate, it still can be struck out for being unconstitutional because Article 8 is not exempted under Article 149 of the federal constitution. And I think this is an excerpt from the case of Dato Harun bin Haji Idris, whereby in the case, the interplay between Article 149 and Article 8 had been mentioned. I will not read out the excerpt. And this is an excerpt from the Reid Commission report as well. The importance of proportionality for laws passed under Article 149 is not a carte blanche license for Parliament to pass any laws that is inconsistent with Article 5, 9, 10 or 13. We're running out of time, so I'll try to skip through. Briefly, what are the complaints? Other complaints about the SOSMA? No bail. I mean, you will not get bail if you're charged for a security offence and when SOSMA is applicable. So essentially, an accused person, is punished even before the trial had concluded. So this is also another situation where it appears that Parliament had overreached into the realms of the judiciary. And then you have Section 30, whereby court has no discretion but to remand the accused even if the accused is acquitted. So, in other words, even if you are acquitted, the High Court has decided that you are not guilty, but the moment there is an oral application by the prosecutor, then the court shall remand the acquitted person pending appeal. So you can see that even though you've been declared by the court of first instance that you are innocent, you still can be remanded. And these are the provisions dealing with protected witnesses as well as special provisions dealing with evidence. We already have the Evidence Act 1950, we already have the CPC, which in my opinion are sufficient in order to ensure a fair trial for people who have been charged with security offences. And then another issue is dealing with SOSMA. The language of security offences under Chapter 6 and 6A of the Penal Code is too vague and open to abuse. Example, acts detrimental to parliamentary democracy as sabotage. The definitions are too wide. Conclusion. Now, it is important that we have laws to deal with threats of terrorism. That's the reality of the situation, that we need to have laws dealing with these situations. But having said that, the laws that we legislate must not be disproportionate to the objective that we are trying to achieve. So if we intend to deal or combat terrorism, let's use that particular legislation for that specific purpose. Do not use it for any other ulterior reason. And that's why I said in the beginning, the law is a tool. It can be used for goodness. It can be used for the benefit of the public. At the same time, it can also be abused. It depends on the person who's using or wielding the tool. And if you can see the last thing, if I say it was oppressive pre-charge, it appears that SOSMA is oppressive once a person has been charged. So you can see that SOSMA, while was legislated with the right objective, but as you can see, it can be abused, and in fact, it has been abused. And apart from that, you can see that SOSMA can be argued to be unconstitutional. Of course, this is my personal view. There may be others who disagree with my views. The federal court may disagree with my views, but that's a different issue. When what we have to appreciate and understand is that whatever laws that we want to legislate, first and foremost, we must ensure that it will not be abused by certain irresponsible quarters. Okay, with that, I will now hand over the mic to our next distinguished speaker. Thank you very much.